Good afternoon, everyone, and welcome to this webinar on unexplained wealth orders in the UK, a game changer or a distraction. We will begin now promptly at 4 p.m., although I expect quite a few people will keep joining in as we go along. My name is Anton Moisenko. I'm a research fellow at RUSI, and in a minute, I will introduce our stellar panel for today. But first, several housekeeping announcements. As attendees, you will have joined this webinar safely on mute and with your web cameras switched off, but you can and are encouraged to participate by asking questions through the Q&A function that you should be able to see at the bottom of your screen. You can also upvote questions that you like and hopefully see your own question being upvoted, which greatly adds to the excitement of the webinar. Should you have any technical difficulties during the webinar, please contact the producer through the chat function that is also at the bottom of your screen. Finally, a quick reminder that this webinar is being recorded. Now, onto the webinar itself. For those of you for whom it's your first time attending one of our events, RUSI's Center for Financial Crime and Security Studies is a research group at the Royal United Services Institute in London that conducts research on UK and international responses to financial crime. And in 2017, like all or many analysts following this area and many research and civil society groups, we were following with bated breath the enactment of the Criminal Finances Act. And of course, one of the key innovations that were introduced in the UK, thanks to the Act, was unexplained wealth orders. Unexplained wealth orders unsurprisingly captured the imagination of the public, partly, no doubt, because of the media coverage of the very first case in which orders were issued. And as many of you will recall, that involved an individual who had managed to spend £16 million in Harrods. But recently, unexplained wealth orders hit the headlines again for a slightly different reason, which was the first defeat by the National Crime Agency in a UWO case. That case related to 3 unexplained wealth orders issued in connection with certain properties in London that, as we now know, appear to be owned beneficially by 2 politically exposed persons from Kazakhstan. In this webinar today, we will reflect on the recent judgment, but also, and perhaps more importantly, we will try to take stock of the place that UWOs have come to occupy in the overall asset recovery effort in the UK. And we could not be joined by a better group of people to have this discussion with. First of all, we have Anita Clifford, barrister and principal associate at Brightline Law. In addition to being a practicing barrister, Anita also is a prolific commentator, and she has published some quite excellent analysis of unexplained wealth orders following the introduction of the legislation. Secondly, we've got James Mather, barrister from Searle Court in London. James also is a practitioner, and in addition to that, James is really the driving force behind this webinar. He came up with the idea of holding this webinar and responding to the developments in relation to UWOs. So we're very grateful to him for partnering with us at RUSI to hold this event. And last but not least, we've got Alan Milford, partner at Kingsley Napley, and prior to that, General Counsel at the Serious Fraud Office. So once again, obviously a man who knows a thing or two about asset recovery and law enforcement. But before I hand over to our excellent speakers for today, let me run a quick poll to gauge the views of the audience. I should say that we've had almost 500 registrations for this webinar, in fact, slightly more than 500 registrations. And I imagine many of those people will have had some prior awareness of UWOs and potentially some fairly strong views on the impact that they have or have not had. So let me launch a poll that will help us get a better sense of where the audience stands on this issue. Okay, I can see people actively voting with a fairly good turnout. So it does seem that a lot of people in the audience have a fairly strong view. Drum roll. Okay, I think I'm going to close the voting now and share the results. So as you can hopefully see now on your screens, there does seem to be a lot of optimism in this virtual room today. And yes, I can see the comment from someone saying that the poll is indeed a tad binary, which is why we are going to ask our speakers for a bit more nuance in this discussion. And I will now hand over to our panel so that they can explain what unexplained wealth orders actually are, and perhaps more importantly, the implications of the recent judgment for the future of unexplained wealth orders. So if that is okay, we will kick off with James. So James, over to you.
Thanks very much, Anton. Unexplained wealth orders were introduced into the UK a bit over 2 years ago now, as Anton says, in the hope and very much in the expectation that the new legislation would transform asset recovery, perhaps above all by slicing through the Gordian knot of disguised ownership structures and shadowy dealings with property. To explain the UK regime in a nutshell to those unfamiliar with it, first of all, what's the effect of an unexplained wealth order if made? It requires the respondent to provide a statement setting out what their interest is in the property concerned, how they obtained it, and other information about the property that the order may specify. And if they don't at least purport to comply with the order, a presumption then arises that they obtained the property through unlawful conduct, so that it's then recoverable by the authorities in civil recovery proceedings under the Proceeds of Crime Act. Those are proceedings in the civil rather than criminal courts. But all the respondent needs to do is purport to provide the information. If they make some stab at it, the presumption does not arise. And even if it does arise, the presumption is a rebuttable one in the later proceedings. Who can an order be made against? There are three main requirements. First, there's a requirement that the respondent holds the property concerned. That's subject to a test of reasonable cause to believe. Second, there must be reasonable grounds to suspect. So on the face of it, a lower and really quite low threshold, that the known sources of the respondent's lawful income would be insufficient to obtain the property. And third, the respondent must be either a politically exposed person, as defined in money laundering legislation, or reasonably suspected of involvement in serious crime or connected with such a person. Again, the low threshold of reasonable suspicion rather than anything more. Legislation also specifically deals with property in trust and company structures, and certainly seems to envisage that an order could be sought not only against the beneficiary of a settlement, but also against a trustee or other person controlling the property in the settlement. And the basic procedure is that the order can be sought at a hearing without notice to the respondent, in other words, without their being informed in advance of it, but that respondent and indeed others affected can then apply to challenge the order. Those are the basics. We've now had three reported instances of orders being made in the English court. The first two cases suggested the implementation of the new powers was going swimmingly well. First of all, an order against Samira Hajayeva, the wife of the former chairman of the International Bank of Azerbaijan, and she of the well-known Harrods connection now, concerning a property in Knightsbridge held in a BVI company. She unsuccessfully sought to discharge the UWO maid and unsuccessfully appealed that refusal to the Court of Appeal. So all well and good so far. Secondly, then, earlier this year, an order against an alleged professional money launderer for organised criminal gangs, again concerning houses as the underlying property, mainly held through companies. There's so far no reported challenge to that order. But the most recent decision, as Anton refers to, National Crime Agency and Baker, is the first serious setback. The case again concerned London properties, this time held principally in a Panamanian foundation and alleged to have been acquired with laundered proceeds of criminal activity by Rakat Aliyev, who was a senior official in Kazakhstan. The earlier cases then were against, respectively, the wife of a politically exposed person in one instance, and in the other, an alleged serious criminal. This time, the principal respondent, a Mr. Baker, was the alleged trustee, or in a position akin to a trustee, of the settlement holding the property, the Panamanian Foundation. And the whole premise of the application really was that the wealth in the settlement derived from Mr. Aliyev's ill-gotten gains, and the order was duly made at the without notice hearing on that basis. But then Mr. Baker instructed a prominent city law firm and challenged the order. And the order was also challenged by Mr. Aliyev's former wife on the basis that the source of the foundation's wealth was in fact hers. And the judge held that the premise of the NCA's application, when those challenges came to be heard, had probably been incorrect, and that she was probably indeed the source of that wealth. And so the orders were discharged. What are the implications of that decision? It's important to say at the outset, I think, that unsuccessful cases in litigation aren't necessarily any sign at all of a wider failing. If you don't lose at least some cases, in my view, then you're just not pursuing enough of them. But the Baker judgment does contain worrying implications for the UWO regime, in my view. 3 points in particular seem to me to arise directly from the judgment. First of all, it exposes, to my mind, particular problems with the drafting and operation of the legislation when it comes to complex holding structures, particularly those arising under the law of exotic foreign jurisdictions. 2 specific problems arose in the Baker case. First, the main respondent, Mr. Baker, held the position of so-called president in relation to the Panamanian Foundation that was concerned. The judge held, on the basis of evidence before him of the, or her, I should say, actually, sorry, of the foundation's structure, that it was the foundation's council and not its president that controlled the underlying property. And second, the judge raised questions about how the income test would be applied in trust structures. In other words, whose income was concerned, and is it only the structure's narrow interest in the property rather than the underlying valuable beneficial ownership that's at issue where you're dealing with property held in that way? I'm not at all sure that the judge got it right on the construction of the statute on those points. But on any view, the legislation was intended to cut through difficult evidential and legal issues as to the operation of complex offshore structures holding property. And as things stand, the message of the Baker case is that it has failed to achieve that particular goal. Second, and relatedly, where an order is actively contested, the court will inevitably apply the threshold tests rigorously. That's just a function of the way the adversarial justice system works in the court in the UK in civil proceedings, and a very good thing too. The fact that the thresholds set by the legislation are fairly low ones in that context makes a limited practical difference, particularly, of course, if there are significant flaws in the evidence relied on in support of the application. And it follows, therefore, that to apply for a UWO is at least potentially to fire the starting gun on very substantial High Court litigation. And that inevitably means that there are substantial risks for the prosecuting agency taking that path. That leads on to a third point, which is this. Those risks beg the question of how often an application for a UWO will really be worth the candle. The judgment in Baker stresses that the jurisdiction is a limited investigatory tool, which really just kicks off the process of civil recovery. If the order is not challenged and the respondent does not even purport to comply, then sure, a valuable presumption comes into play, the presumption that the property is derived from unlawful conduct, which then founds the civil recovery claim. But one wonders how often that will happen in cases where civil recovery proceedings would have been defended in any event. It bears repeating that all the respondent has to do to prevent the presumption arising is to purport to comply by providing some sort of response. They can still dispute the facts when it comes to the civil recovery proceedings themselves, because the presumption is a rebuttable one. Is it worth the tactical risk of an application for an unexplained wealth order for that limited gain, given the substantial evidence required to obtain that order in the first place and the costs risk that may well arise where it's actively contested? There will be cases where the answer is yes, but Baker, as it stands at least, undoubtedly reduces their number to my mind. So that's my opening gambit on where Baker leaves us. And with that, I'll hand over to Alan for his thoughts on it.
Thanks, James. So my thought when the Baker judgment was reported was that this was a marvellous illustration of how actually the authorities can never win in this kind of case. And I think in part that's as a consequence of the messaging which surrounded UWOs. And it seems to me there were two very different messages which were put out there. The first was the message to the public that UWOs were in themselves this game-changing device which were going to bring an end to the McMafia culture which infested London and the wider country. And then the more careful, nuanced message which was given to law enforcement when UWOs came into force. And that was the message contained in the Code of Practice, which is the relevant bits of which are to be found in Mrs. Justice Lang's careful judgment. And it's a reminder that this is simply an investigative tool, that it's intrusive in nature, and it should be used very carefully. And you need to think about whether there are alternatives before you use that tool. And I think having put down Mrs. Justice Lang's judgment, and I should say I recognise the NTA are going to appeal and I don't know the underlying facts, but reading her analysis of the evidence and the sequence of events, my thought was actually you might just add the point that your decision to go down the UWO route is one which needs to be kept under pretty rigorous review, because significantly in this case, the UWO litigation started, and before the respondents were to provide evidence or provide their information, the lawyers for them wrote to the NCA and set out in some detail, underpinned by apparently underpinned by pre-existing documents, quite a lot of information about who the ultimate beneficial owners of the properties concerned were. And reading the ruling, I can't see that there was much heed paid to that, or that there was any real attempt to stop and think about where this leads the investigation. So for me, the first takeaway is really you need to do that. And I think Mrs. Justice Lang was unimpressed that that hadn't been done. In the circumstances of this case, the information the solicitors provided included quite a lot of family background as well, which made the point that whereas there was a case theory and an assumption, a word she used many times during the course of the ruling, an assumption that all this property ultimately belonged to Aliyev, who was accepted to have been a criminal, there'd been a very significant split in the family, that his former wife was very, very well connected herself, and her pet was independently wealthy, that people didn't talk after Aliyev had had his divorce and had an affair and remarried. All those things should really have made them, it seems to me, reconsider the case theory. I think also there's a point in the ruling about the sorts of inferences which you can draw from offshore structures. James made the very fair point that there are there's an anxiety about complex offshore structures and an understanding that it is a manifestation of money laundering practice around offshore structures. But the courts have never disagreed with that. But they've also been very, very clear that offshore structures can be used in a lawful and legitimate manner. And they've been very careful about the inferences which can be drawn by the state when seeking remedies and proceeds of crime simply from the existence of offshore structures. And Mrs. Justice Lang issued another reminder about that in the course of her ruling. James made the point about how well suited UWOs are to cases involving service providers. Mrs. Hajiyev's case, she was the ultimate beneficial owner. There was no issue about holding. And in this case, this was a professional who had control over the property for apparently an unknown beneficial owner, notwithstanding the evidence that came to light. The problems were with the holding and income requirements. And the analysis there was very interesting, very detailed, and included the point that they aren't to be treated lightly. And there was a particular difficulty, it seems to me, the NCA had in establishing that someone who as a professional was exercising as a professional who they said held the property to prove their case on the income requirement. All of these points would have been quite irrelevant had the NCA chosen to use a disclosure order. And disclosure orders are available under the Proceeds of Crime Act. They don't require holding or income requirements to be met. They do require an application to a judge. They are intrusive remedies and consequently require a judge to believe that they would be of substantial use in the investigation, and the judge has to apply a public interest test. The limitation on disclosure orders is rather that you have to be in the jurisdiction before you can be made subject to a disclosure order. But Mr. Baker was a solicitor of England and Wales and no doubt could be in the jurisdiction at some point during the course of a year. And that brings me to, I guess, sort of the wrap-up point. And again, it's touching on the comments James made. UWOs are simply a tool. They're not the ultimate means by which proceeds of crime legislation works. It's either a civil recovery order or a confiscation order properly enforced. And perhaps the lesson from Baker is if you use the tool or the wrong tool in the circumstances of the case, then you're going to suffer some quite severe consequences. And there's an issue about the impact of the cost orders in this case and what impact that might have on risk appetites going forward. But I'd suggest the real sort of measure of impact is not about whether there are more or less UWOs. The real question is whether there's more or less use of the civil recovery jurisdiction generally, and I think that's more of a sort of wider point. But anyway, Anita, I think you've got some thoughts as well on this.
Thank you, Alan. On reading the judgment, I think my primary thought was arguably it is an example of UWOs really doing what they set out to do. As I think Alan and James touched on, it is one of a suite of investigative tools, really, which can be used when there's no information at all of any nexus between the property and any illegal conduct. It's really something which can be used at the outset. Here, the NCA, of course, was not victorious, but one might think, well, they were successful, of course, in getting the UWO ex parte at first instance, and then a large amount of information was ultimately provided by those who said that they held the beneficial interest in those properties, which were indeed identified as being suspicious. So although the UWOs were lifted, and a lot can be said about perhaps the tool being ineffective or something else ought to have been used, I do wonder whether it has actually gained access to information which otherwise would have remained very secret indeed, in terms of, well, who actually owns these properties, what exactly is the provenance of some very high value properties in London. So that was my first thought about the judgment. I think also it's important to remember, whilst this is certainly a significant setback for the NCA, on reading it, it's also a very fact-specific one. There are a number of factors which James and also Alan have already canvassed, which showed that actually at the end of the day, the basics in terms of the basic ingredients for the making of a UWO simply weren't met. And I do have some sympathy for the NCA, particularly when it is a tool arguably used at the very outset of an investigation where law enforcement is met with shadowy, opaque foreign structures, exactly how they can necessarily penetrate those structures to understand who exactly holds them. I think that that is something which was always going to be a problem. And unfortunately, in this particular case, it proved, or has proved thus far, a hurdle too great. So those are the two sort of broader thoughts about the judgment. There are some other things, though, which arise out of the judgment, which, in my view, will affect how practically UWOs will operate in the future. Or how they will be responded to. There were some interesting things to learn. First of all, as I think James said at the beginning, Mrs. Justice Lang spoke about how there seems to be a real issue with understanding how the income requirement really works when it comes to trusts and so forth. There are other ambiguities in the legislation. We saw in Haji Ava, for instance, that exactly who is a PEP, the level of state interest in a particular enterprise, to what extent is that required before somebody is a PEP, that needed to be clarified by the court. Now we have the income discrepancy needing again to be clarified by the court. There are others that I've picked up as well about exactly how, say, immunity principles might arise if one does try and use a UWO against somebody in high political office. There are lots of ambiguities, one might think, in the legislation, which the court, in the two major judgments that we've seen so far, are starting to tease out. Another smaller point, which, and this is, of course, there are a number of other points to talk about, but I'm just conscious of time. One thing I'm particularly interested in Baker was that the court seemed to express some sympathy and certainly relied on, in part, the findings of a Kazakh investigation, which cleared any flow of property, of so-called illicit property, to the ex-wife of Rakat Aliyev. It's very interesting in my book that a English High Court is willing to rely on the findings of a Kazakh investigator. That might align, one might think, with in Hajieva, some reliance was placed on by the court on Azerbaijan convictions. And I think it's interesting that countries which don't necessarily have the strongest record for rule of law are finding their way into English High Court judgments when it comes to applying UWOs or indeed discharging UWOs. So some thoughts about that. Two sort of broader things. My primary position is I think that UWOs have great utility, and arguably this is an example of getting information which otherwise would not have come to light at all. I think back over to you, Anton.
Thank you very much to all three of you for this excellent overview. Now, could I ask you to develop the theme that I think all of you have touched upon in quite some detail already, but it would be interesting to explore further, namely the use of UWOs as part of a broad suite of measures aimed at asset recovery and ensuring that asset recovery in the UK proceeds successfully with the use of unexplained wealth orders as one component of the overall effort. What, in your view, are the key barriers or challenges that need to be overcome for that to happen? And also, relatedly to that, I know that you, Anita, in particular, have done some interesting comparative work in other jurisdictions, and you have some expertise on how other countries approach similar challenges related to tackling unexplained or illicit wealth, and they don't necessarily do that in quite the same manner as the UK does. So it would be great to get your reflections on that as well. But if you don't mind, maybe we could go in the same order as we did the first time round. So James, Alan, and then Anita.
Thank you, Anton. Well, I'd very much agree with what I think both Alan and Anita said, that a really crucial aspect of the experience of UWOs has been the degree of publicity they've obtained. And the very valuable aspect of that is the light they have shed on the importance of asset recovery. But the flip side of that, I think, is a danger that they've almost become a proxy for civil recovery proceedings, and better known than the underlying civil recovery proceedings, when I think we've all agreed that that's not what they are. They're much more limited than that, and they are simply a tool to assist in civil recovery proceedings. And so, very much echoing what Alan said towards the conclusion of his remarks, the real question is how to increase the use of civil recovery proceedings. The powers, the civil recovery powers under the Proceeds of Crime Act, enabling recovery of the proceeds of crime without a criminal conviction and applying civil standards of proof, are strong ones, compelling ones, and to my mind, plainly underused. And the challenge in relation to that is not one about what powers exist. It's a question of enforcement and under-enforcement of the existing powers. And I think that was the case even before UWOs were implemented. In short, a substantial increase in the use of the powers will undoubtedly require a substantial increase in the resources that can be brought to bear. My own view is that that's only likely to happen through a use of public-private partnership models, so as to bring to bear both the financial and human resources of the private sector on asset recovery for the public benefit. What's perhaps striking at the moment, and very much borne out by a case like Baker, is the strategic mismatch that you get in cases where, as in that case, the respondent then goes off to an expensive city law firm and fights the order tooth and nail. And I take on board what Anita says about the order there, or the proceedings there, having been effective in practice at causing information to be provided, which may well be valuable, perhaps very valuable, but at an enormous cost, an enormous tactical and strategic cost in terms of the proceedings. And it does seem to me that in proceedings of that kind, one has to see them very much as, in effect, or at least from one point of view, commercial proceedings or proceedings of a commercial character, where incurring costs orders has an enormous strategic consequence on the wider litigation. And so even if you manage to obtain some useful information, that can only be part of the picture. So to take it back to the wider point, all this underscores the need for greater use of the civil recovery powers. What I would hope is that the publicity that UWOs have obtained will help to support a wider use of civil recovery powers more generally, but that is going to require new approaches to the resourcing of those proceedings, seems to me. But with that, I'll hand back over to Alan for his thoughts on that point.
Thank you, James. I don't disagree with you at all about resourcing for the activity. You can only, when you work within the public sector, you're given a budget for the course of the year. These aren't complaints, these are just statements of fact. You know, from 2010 onwards, budgets were cut in line with the wider government policies as a consequence of the banking crash and the subsequent recession. And whilst governments have to make decisions about how funding is given, there are some consequences from that, and plainly it's difficult to maintain big investigative and prosecutorial resources on every aspect of the casework which you have to do. So yes, there needs to be, if we are going to, or if there is going to be a change in proceeds of crime enforcement or success rates or the amount of money that's brought in, there does need to be a question of political prioritization about funding. And then falling out of that, there's a question about the funding model and the way in which resources are put. Is it all done by an enlarged sort of state function, so that bigger proceeds of crime units in the SFO or in the Crown Prosecution Service? Is it done with that plus public-private partnerships? But those are up for debate, it seems to me. If there is a public-private partnership, I think what's going to make a difference would be a way in which you could find a funding model which aligned between essentially the private sector funding models and around which the court remedies or the funding models have been designed so far in civil litigation, and then the public sector, which gets its budgets on an annual basis, a fixed sum, and no ability really to call on a reserve as and when things might go wrong. So there's a big debate to be had about that. In terms of success, what was it that my experience of work when I was both in the CPS and the SFO, when you look at the performance of the proceeds of crime teams and their ability to enforce orders, it was actually very good when it came to orders in which assets were identified and wherein the United Kingdom, because they're within our jurisdiction and we had a very sort of simple and clear route to be able to enforce it. The bigger orders, the ones which cause the public anxiety and the loss of confidence, generally in the way in which people are able to get away with venal criminality, are those cases in which there were hidden assets or in which the assets were overseas. And in terms of hidden assets, well, your only enforcement recourse is in respect of individuals, and we have default sentences for that. And the question is, are people willing to go to prison rather than pay across huge sums of money, if they still have them? And then the second aspect is the international enforcement. And that's not going to work without essentially two willing partners working on the enforcement case. You've got challenges around the way in which mutual legal assistance works, the resourcing which is put into incoming requests by various states across the world, the confidence that states have in litigating complex issues of property law. Some, Western democracies are more up for doing that than other countries are. And you've also got the complication of the way in which mutual legal assistance works. It can be quite cumbersome, not necessarily quick, although, again, I'd say that my former colleagues in CPS and SFO know very well how to deal quickly with incoming requests and to turn cases round well and get in front of a judge to try to get a restraint order, but it's not necessarily the same service across the world. And so there's a weakness there, I think, which isn't going to be solved simply by action within a state. It needs to be a partnership. And just more generally around the theme, the High Court jurisdiction is, a demanding jurisdiction, and again, no complaint. We're a rule of law jurisdiction. It's one of the great things about this country, and we do have to be able to know that there's an independent judiciary who are going, with an independent mind, fairly to scrutinise the evidence, and Mrs. Justice Lang laid bare her analysis of the evidence in that case. But it's very resource intensive to prepare for that, back to your point, James. But if you're going to put that level of resource in, you might as well, it seems to me, think about either looking for prosecution, because the amount of time and effort you're going to put into the civil recovery, why not run a criminal investigation as well? Or you're going to be attracted to, the summary jurisdiction for civil, which is in cash or an account forfeiture. And that's one of the recent reforms which has seen a lot of activity, particularly account forfeiture. It seems to me there are questions about that, in the sense of a summary jurisdiction for determining what can be really quite complex questions of property ownership, or of rights to bank accounts, of property ownership in that sense, and a jurisdiction without any sort of established procedural rules for determining civil cases, no filter through which you can go up to the higher court for the more complex cases, as happens ordinarily in civil litigation, the valve between the county court and the high court. So I think there are questions to address there. But look, I've probably taken more time than I need to, and I know that Anita's got some thoughts on the international angle.
Thank you.
Over to you.
Yes, just picking up on comment about how resource intensive UWO proceedings are. It's interesting because I was looking over some of the earlier Hansard debates when the bill was going through, and of course there was a cost capping amendment, a proposal to cap costs for UWO proceedings, which wasn't ultimately successful. In terms of just the sort of fallout from Baker, one wonders whether we might see cost capping proposals back on the table if they are going to be such hotly contested proceedings for UWOs. Though just zooming out and looking at alternatives, I suppose, to the UWO regime, although it's part of a suite of investigative powers, as opposed to its own asset forfeiture proceedings in its own right, there are similar proceedings that were from my home jurisdiction of Australia, where actually what has happened in terms of criticism of it being a very invasive tool is certainly what the Australian experience tells us. It's used very sparingly there. Within Europe, though, which is where I've more recently done a lot of work in Eastern Europe, looking at different civil recovery models, what I've found is that there's been, in a lot of countries where corruption is a real recognised issue, being resistance to non-conviction based forfeiture, and very much a preference to look at things through a criminal prism, whether that is perhaps a criminal investigation being on foot before any civil type proceedings for assets are launched, or even the introduction of an illicit enrichment offence, which is where, say, where there's a discrepancy between one's wealth and a particular property, or a discrepancy of a certain amount, actually that can trigger criminal liability. We see countries, I think Lithuania, Ukraine, and a few others certainly go down that route, rather than looking at UWO style proceedings, which would be long-running, resource-intensive litigation. That, of course, a lot of people might remember, was certainly on the table at one point in the UK, but it was thought to not be compatible, particularly with our human rights regime. There are very serious due process considerations there in terms of presumption against innocence being infringed, self-incrimination protection, perhaps difficulties with clarity in how the offence is framed. Those are some of the main reasons why the UK didn't go down that route, and indeed chose to go down the UWO route instead. Another point, though, is what I am seeing is, although, say, a lot of the Eastern European countries have been reluctant to look carefully at civil recovery and different innovative investigative tools, in the last year or two, particularly since UWOs have been launched here in the UK, we are seeing really quite a lot of interest. Countries which have had an illicit enrichment offence to date have, at least domestically, had to deal with a number of constitutional challenges to that offence, some of which have been successful, thinking most recently in Ukraine. And they're interested in looking at other ways of doing things, which is why the UWO experiment, if we can call that here in the UK, might actually inform some of the other approaches that are being taken. Just to wrap up, though, because one sort of major criticism of UWOs has been, well, it's a very intrusive tool, there's a reverse onus, it compels people to provide information, how can that really be fair? I would just make the point that the UK is certainly not alone in taking that approach. We have European Court of Human Rights looking at reverse onuses, endorsed that approach. Interestingly, we also see in Jersey, I think about 18 months ago, have an express reverse onus provision when it comes to account forfeiture. And actually a slightly lower test needs to be met in Jersey for money in bank accounts to be forfeited. That goes to your point, really, Alan, because that is summary jurisdiction and certainly a more robust response to taking money in bank accounts, but really putting the onus on the person to satisfy the court that the money is clean, otherwise it will be swiftly taken away. So they've gone down that route rather than much lengthier intensive proceedings. Back over to you, I believe, Anton, for any questions from the audience.
Thank you very much, Anita. Yes, indeed, we've got a veritable treasure trove of questions. So let's delve straight into that. We did have a question on cost capping from Duncan Hames, but if I may, maybe we will put that aside for the moment, just not to let the question of costs and money dominate the entire discussion. We did have a question that was upvoted quite a few times from Oliver Bullough, and I will just read it out. Was the failure in the Nazarbayeva case a result of a flawed case brought by the NCA, or a weakness in the concept of the UWO altogether? And I suppose that links to several points that all of you made, one of those being the tension between obtaining a UWO early in the life of an investigation to get information you would not otherwise have had, but on the other hand, then you run the risk of not having enough information at your disposal to defend the issuance of the UWO, as we have seen happen. And another aspect to this is that maybe in the UK, the choice that was made in designing UWOs in the way that they are has gone far towards protecting individual rights, perhaps at the expense of the efficiency of the tool. So I suppose the question here is really, what is the main lesson from the Baker judgment? What is the key takeaway that we should go away with? So if that's okay, maybe you, Anita, could have a go at answering it first.
I think going to Oliver's question, I think that this decision really comes on the back of what are very fact-specific deficiencies. I think in terms of the real takeaway, I suppose it goes to how the NCA approaches cases of this kind. They certainly had sufficient information to get the order ex parte, but I think the key takeaway for me is, did it necessarily need to get to the point of an application to discharge being made if once the UWO was obtained and was served, they then essentially got all the information that they required? Did they actually carefully look at it and scrutinize it? Or are they still feeling their way in terms of how to respond when they get a UWO in the first place? And are they actually being open-minded in terms of potentially reconsidering their position? That to me is one of the key messages which arises out of this decision, because it didn't necessarily need to go this far.
Anything to add from you, Alan?
Yeah, I agree very much with what Anita said, that the mantra is all cases are always under review. And the letter having come in from the solicitors giving an entirely different explanation for who the ultimate beneficial owner was of that property, then it seems to me that the NCA may have decided, well, okay, let's take stock, let's look at this new information, let's look now at how, in light of that new information, we need to take forward our investigation. That may mean going back and seeking UWOs in the future, but it may mean using other remedies and looking instead at other tools. So it's not wrong. I don't think you can say the NCA was wrong to look at the case or to open an investigation. The question is whether it needed to pursue it in the way it did for the reasons Anita described.
Thanks. James, you wanted to come in.
Yes, just on the broader point of how far that case is, as it were, confined to its own facts. Clearly, to some extent, that's the case. But I think what comes out of the appeal of that decision, assuming that the NCA gets permission to appeal, will have a wider importance on the question of whether there is a flaw of some kind in the instrument when it comes to how it relates to to trusts and settlements of all kinds. And I think if the construction put on the statute by that decision is upheld, it will mean that the legislation doesn't achieve the intention of really making it much easier to deal with, as the title suggests, unexplained wealth, and the implementation has fallen short, I think, in a way that probably wasn't intended. So that, I think that's going to be an important question, and it remains live in the context of an appeal. And I'm assuming that those are aspects I would imagine would form part of the grounds on which the NCA would seek to appeal. Just also on the question about whether the measures have gone too far towards respecting individual rights, and picking up on something Anita was saying about concepts of reversing the onus of proof and the obvious concerns that arise in relation to that. It does seem to me that from that point of view, the provisions are quite gentle, and one can understand why they were drafted in that way. But what we haven't yet seen is what might happen where an order's been made, there's purported compliance with it, but when it comes to the actual proceedings, there's an argument about whether any sort of presumption arises, because there's purported some degree of purported compliance, and one can imagine the sorts of arguments that will arise in that type of context, and all you then get really is a bit of satellite litigation about whether there's a presumption or not, which is often then quite unhelpful in terms of making the litigation progress more smoothly. So I think that is in a sense a weakness in the legislation, perhaps a necessary one, because I think it was necessary to have regards to the concerns that arise from reversing an onus.
Thank you. And another question that I would like to take is one from Joseph Sinclair, which is a nice, straight legal question. So Mrs. Justice Lang said that the use of complex corporate structures and trusts are not in and of themselves sufficient to give reasonable grounds to suspect. Correct? Incorrect? What are your views on that? Shall we maybe go to Alan first?
She went over a number of cases, and there were more she could have gone over as well, and made the point that when it comes ultimately to drawing inferences from the from having held assets in offshore structures, it is not enough in and of itself to be able to say because it's offshore it is necessarily criminal. And the point is illustrated in the facts of this particular case, because one of the things which attracted the attention of the and suspicion of the NCA was that the first property was held in a BVI company, and then it was transferred in 2013 from a BVI company to Panamanian Private Interest Foundation. And it was in 2013 that tax rules changed. There was the loophole in the tax rules was did not, or had been may well have been plugged around the BVI companies, but not for Panamanian Foundation. So the property was moved into Panamanian Foundation. That it was moved at that time was in that year gave rise to an inference as much as anything else that it was a tax avoidance measure and not a sort of crime measure. So that was the point she made. But the point's been made many times before by many judges in many, many different cases.
Okay, thank you. Anything to add to this from Anita or James?
Oh, you go ahead.
No, please, Anita, go ahead.
I was just going to say I agree entirely with what Alan said, and there could be really very legitimate reasons why offshore structures would be used. We know in certain jurisdictions where one falls out of favour with the government, their assets, which may well have been very legitimately obtained, come to be up for grabs. And so that's just one legitimate reason why such a structure would be used without necessarily being suspicious.
I perhaps take a slightly different point of view. I certainly wouldn't suggest that the mere use of an offshore structure supports an inference of criminality, full stop. Absolutely not. But I think the main context in which the courts have been looking at this before is in the context of the risk of dissipation in freezing orders in civil proceedings. It does seem to me that one has to look at the potentially appropriate inferences to be drawn in the specific context in which the question arises. Here, the context was an application under this specific provision, and even where there's a legitimate purpose to the use of the structure, often it will have something to do with making, as it were, anonymous the source of the wealth, even if that's for a legitimate reason connected with security or whatever it may be. And so it does seem to me that it's an issue that merited perhaps fuller consideration than the judge gave it in the Baker case, so far as it applies to the context of applications for UWOs.
Thank you. I realize we've run out of time, and one of the frustrations of having a webinar is that you see all the great questions you don't have the time to answer. But if I may, I would just put two combined questions from Richard Gould to the speakers, which both relate to the effect of publicity that UWOs have generated on the asset recovery landscape. On the one hand, there is a risk of unrealistic expectations, yet on the other hand, perhaps it is not such a bad thing that there is a greater focus on civil recovery and some criminal justice matters related to corruption and money laundering than ever before. So what would be your high-level observation on that? So if that's okay, we can just revert to the original order and go to James, Alan, and Anita for those final remarks, or perhaps anything else that you'd like to mention in your final statement.
Yeah, I absolutely agree with that observation, and it would be a great shame if the effect of the judgment in this particular case, and of course we don't know what might happen in the Court of Appeal, were to arrest the momentum that has been generated by UWOs towards attention on asset recovery and a recognition of its importance in the context of combating crime. So I very much agree with the observations in the question.
I think the messages were mixed. As I said at the outset, there was a message for the public, and then there was a message for the operational agencies, and I don't think that's ever helpful. I think that there is quite properly a real public disquiet about the injustice, really, of people being able to live easy, comfortable lives on the back of dirty money. And the public rightly wants something to be done about it. Sometimes publicity can create unrealistic expectations of what is and what is not possible for agencies funded as they are by the same people putting out those public messages, operating, as we've described, within a rule of law jurisdiction, and in the context of dirty money being a global phenomenon, not simply a British phenomenon.
Yes, I would agree. I think the hype around UWOs, really when they were introduced, a lot of the other perhaps more effective tools or widely used tools just didn't get the same level of attention, has placed a lot of pressure on law enforcement to bring cases and perhaps bring big splashy cases. That said, I think that there's a wider message around the introduction of UWOs, which fits in with a lot more, I guess, action being taken to strike at money laundering. The actual introduction, I think, still has very much a deterrent effect on perhaps people bringing their illicit wealth to the UK, certainly those who have wealth in the UK who are ultra high net worth, being concerned about how these powers might affect them. For the regulated sector, from a money laundering perspective, I think that the message, because there has been so much hype around them, UWOs also encourage a lot more questioning around the provenance of client wealth as well. So perhaps some of that hype is justified and actually has utility.
Well, thank you. On this note, the final part of the webinar is just rerunning the poll so that we can see if anyone's views have changed following this very informative discussion. And okay, it looks like much more of a tie at the moment. Okay, so I'm going to close the voting. And as you can see, maybe it is just me choosing to stop the voting at a very auspicious moment, but it is 50-50.